Yes, it rained after the asphalt was taken up. But guess what? My client did his due diligence in that they pumped the water off and they made the soil as dry as they could and they put it down. Now, Paul Harvey is one of my favorite journalists. And Paul Harvey, I don't know if you remember him, but he always used to say, let me tell you the rest of the story. There's some of this story that they've left out. Remember Jeremiah Bryant sitting on that stand? Remember when I sat there and I asked him, I said, how, and I knew what the answer was. I said, how wet was it? No, it was real wet. I said, when you walk on it, could you see the water under your feet? Yes. And when you walked on it and it was wet, was the track itself wet? He said, yes. And that's when I put up the picture of the picture of the truck with dust flying up. Can't have it both ways. If it was wet and they were paving, there wouldn't have been any dust there. So let's just think about that. And I'm going to tell you, there's something else that they refuse to talk about, that their expert didn't talk about, that we all remember, the 1,000-year flood. 26 inches of rain in less than 48 hours. Biggest flood we ever seen. Black River was inundated. You couldn't get from Kingstree to Andrews on 527. I've never seen anything like it, and I certainly none of you had seen anything like it. But let me show you something, because they came back to do some work in 2016, January of 2016. After the pavement was done, they pulled up the concrete. What do they find? Water. That water's there for a reason, and we all know why. The catastrophic amount of rain that this area received, and that area being what it was, with the soil conditions it was wet. It's nobody's fault, it's an act of God. They're asking you to punish Mr. Smith. And that's not big words that I'm making up. That's going to come from your jury instruction. Punitive damages are to punish. They want you to punish a self-made man who came out there and did his best work. Now, there's some things that you can do. You're on this jury not because of your technical expertise. You're here because you don't need that. You need the good common sense that the Lord gave you. If you've got children, you know that little voice in your ear when your child's telling you something, and that little tinkling says, yeah, she's telling the truth, or no, that's not how that goes. They want you to believe that this gentleman with 60 businesses that he's started, that he's done so well in Charleston, that in just this one particular instance, he's naive. He's a babe in the woods. He's been bamboozled, led astray, hoodwinked. You don't amass the amount of money that Peter Evans amassed to the point where you can call a $200,000 investment a small investment by being stupid in business. He's no dummy. He's smart. And for him to come in here and to suggest to you that this man took advantage of him, I submit to you that little voice in your head doesn't add up. Now, they go on ad nauseum about the contract, and we all admit that there is a contract. I want you to read on the contract specifically. We're going to read item 4. And it says, this quote is excluding permits, fees, bonds, removal, and replacement of unsuitable soils, landscaping, irrigation, and site utilities. Mr. Savage glossed over that. He mentioned it, but he hoped you didn't see it. It's written in the document. This is the document that Mr. Evans signed. He knew that my client did not have a duty to fix the substrate. Now, They also want you to believe that from the onset, this work was just deplorable. It just didn't make sense. And because they said, what did they say? As soon as they stopped, we started picking up bits of asphalt. And they had Jeremiah tell you about that. Well, I want you to know that in January 2016, 4 months after they did the work, they're sending text messages. Hey Charles, Marlo and I thought about it. And we came up with an idea. If you wanted to advertise at the track, you could pay for the cost of the signs and we would put them up for you for no charge for the first year, since you have really helped us out. What does common sense tell you? Do you want somebody who's done a horrible job for you to advertise at your place and you're gonna let them do it for free? That doesn't make sense. Someone told me when I first went into business for myself, they said, be careful, because when you do good, people tell all their friends. And when you do bad, they tell everybody. So if it was so bad, so egregious, so substandard, so beneath the quality of workmanship, why then do they want to have his sign there as a constant reminder of what they call substandard work? Ladies and gentlemen, that doesn't make sense. I want you to understand that the patching that they have to do when they call Mr. Smith out there happens after the 1,000-year flood. And we know what's going on beneath the soil. It's saturated, it's wet, it's moving. So that's not his fault. That's an act of God. Now, they also make it seem as if because he's a general contractor that he hired subcontractors, that that's somehow shady. If you've ever built a house or had someone do work, the general contractor comes, but they bring a guy that's a subcontractor to do the plumbing, somebody to do the electrical. And in this instance where he recognized that he wanted to give them, he could have just used his machine and had a seam down the middle, but he reached out and got another business to come in and do it where they wouldn't have a seam in the track. And yes, there is a markup. And guess why? Because there's a 30% markup on anything when you have a sub come in. Yes, it is business. It is not a deceptive business practice. That is the industry standard. Now, let's talk about this. They talked about all these options you have. And they showed you all of this big money on the board. Millions. Your options are to give Mr. Evans a track that he didn't even have before? No. If you find for him, the law says you got to put him back in the condition that he was. In the condition that he was in prior to the track, as he had a 20-year-old rundown alligatoring track that was substandard, and because he didn't do his due diligence when he bought the track, he now wants to gain by ending up with a brand new state-of-the-art facility at Mr. Charles Smith's expense. That's not right. That's not how we do. That's not how things are done around here. I want you to understand that my client has had to wait since 2016 for payment. My client has still had to make payroll. And yes, he's successful. And that's not a sin. That's what you go into business to do, to become successful. But I submit to you, he's done it the right way. He's had to wait. Now let's also talk about this check that they've gone to great lengths to explain. I can read. I know opposing counsel can read. And I know you all can read. This doesn't say cancel check. This doesn't say stop payment. This says insufficient funds. What does that mean? There ain't enough money in this account. Now, they've gone to great lengths to talk about honesty, or what's not honest, or that my client's not honest. Well, it's not honest to write a bad check. It's not. It's also not honest to repeatedly promise to make good on something, as the text messages as you can read, saying, hey, when can I pick up the rest of my money? Oh, it's coming, it's coming. That's not honest. I'll come in here to try to trick this gentleman, and somehow he isn't smart. He's told you, I've got 60 businesses. I've started 60 businesses, starting with a paper route. And he also told you that, he knows a little bit about everything. Racing, he's raced a motorcycle. I've gone to different tracks. But just when it comes to the quality, of the workmanship, or how the track was when he bought it, I don't know anything about that. That's not, ladies and gentlemen, that's not honest. He wanted Mr. Smith to basically make bricks without straw. He wanted him to just go ahead, get the track running. And I submit to you that that's the most believable story. My client milled, yes, he did mill it. He milled it at 2 inches. And while we're talking about milling, I need to jump back to something. Mr. Sabb goes to great length to talk about profile milling. Profile milling. Profile milling, it's coming out our ears, right? There is nothing on this contract that says profile milling. Nothing. It says mill existing asphalt track to establish a smooth profile. Doesn't say profile milling. It's what it says. This is what it says. And he says sweep, clean, and apply tack coat. Finish in place and compact 2 inches of asphalt surface course and clean entire construction area when complete. That's what's in the contract. That's what's there. Now, they talk about their expert. Yeah, he sure did a diligent report, but it's not what he says or what he left out. Didn't mention the 1,000-year flood. You would think someone with that level of education, as they went to great lengths to explain to us how smart this fellow was, you'd think that he would note how we all thought Noah was coming back in October and put that in their report. Because that's significant. We saw everything that got washed away. We saw all the roads that had to be rebuilt and the bridges that had to be replaced. Same concept. And when you couple that rain with the fact that they put it on a clay surface, that's what you get. Just like Mr. Lee told you, if I'd have built the track, I'd have put down hard substances like granite. But they want you all to come in here, punish him, and give him a brand new track, which he knew that the track wasn't any good, but he let people race on it, and he didn't even advertise it. IHRA, International Hot Rod Association. He's telling the world that I'm a member track, that it's good, but he says it's bad. And if he sees instantly that the asphalt is so bad that it's coming up in clumps, he's still gonna let the people race? No, that's not what happened. It was a Good Friday night at the track, every night. And by the way, he was racing. See, the proof's in the pictures. This is October 29th, 2016. This place is packed. They've got people that have brought these things right here are all trucks where people have hauled their dragsters there. They are racing. So for months after my client did his work, they're out there running and gunning, making money, and ignoring him. Ignoring him. treating him as if he's a bodyguard and lying to him. Yeah, we're gonna pay you. Yeah, we're gonna pay you. No, ladies and gentlemen, that's not right. They've asked you, they brought in, and see, the trick is, let me put these big numbers in front of you guys, and you'll enrich him. I submit to you that what we have is not his case. It's his case. He sued for $56,000. Do you see him up here concocting any brand new numbers? No, he wants what? What he's owed. Now, I promised I wouldn't be in front of you long, and I don't think I need to be in front of you long, but I want to leave you with this. Mr. Sav asked you to say, please, and put some numbers with it. I'm going to ask you to tell Mr. Smith, thank you. Thank you has 8 letters. And you should put a number for each of those numbers. You should put a 5 for the T, a 6 for the H, a 0 for the A, a 0 for the N, a 0 for the K, a decimal point for the Y, a 0 for the O, and a 0 for the U. Tell him thank you, give him what he should have done, and pay him the money that he's earned. Thank you all for your time. I appreciate you so much.
Mr. Foreman and members of the jury, you've heard the testimony, received the evidence, and heard the arguments of the plaintiff and the defendant. I will now explain to you the law that applies to this case. Under the Constitution and laws of South Carolina, you are the finders of the facts. I do not have to express any opinion that I, because this is a matter solely for you, the jury, to determine. And duty to determine the effect, the value, the weight, and the truth of the evidence presented during this trial. As the trial judge, it's my responsibility to preside over the trial of the case and rule upon the admissibility of the evidence offered during the trial. You are to consider only the testimony which has been presented from this witness stand, together with the exhibits which have been made a part of the record. I have the additional duty to charge you the law applicable to this case. And as the presiding judge, I am the sole judge of the law of this case. It is your duty as jurors to accept as correct and apply the law as I now stated to you, and then deliberate to reach your verdict. All right, Mr. Ford, if you'll stand for me. Do you have a verdict?
Yes, Your Honor.
Is it unanimous?
Yes, Your Honor.
All right, if you'll pass it up to the clerk. You will pass it to me. You may be seated. You may publish the verdict.
In the Court of Common Pleas, 3rd Judicial Circuit, case number 2016 CP 45-00293, State of South Carolina, County of Williamsburg, Charles Smith and Company LLC, plaintiff versus Peter Evans individually, and DBA Midway Motorsports Park, defendant. Peter Evans individually and DBA Midway Motor Park Sports and Cliffside Motorsports Park, LLC, counterclaimants versus Charles Smith Company, LLC, counterclaimant defendant. Number 1, do you, the juror, unanimously find that the plaintiff, Charles Smith Company, LLC, established by the greater weight of the evidence that the defendant, Peter Evans, individually, and DBA Midway Motorsports Park is liable for breach of contract and or upon the merit beneath confer and promissory estoppel? Yes. Go to question 2. We, the jury, unanimously find that the plaintiff, Charles Smith Company, LLC, is entitled $57,986 from the defendant, Peter Evans, individually, and DBA Midway Motorsports Park, and for breach of contract and upon merit and the promissory estoppel. 3, do you, the jury, unanimously find the defendants, Peter Evans, individually, and DBA Midway Motorsports Park and Flipside Motorsports, LLC, established by the greater weight of evidence that the plaintiff, Charles Smith Company, LLC, is liable for breach of contract and or the implied warranty of workman-like service? No. Moving on to 5. Do you, the jury, unanimously find that the defendant, Peter Evans, individually, and DBA Midway Sports Park and Flipside Motorsports, LLC, established by the greater weight of the evidence that plaintiff Charles Smith and Company, LLC, is liable for negligence? Yes. 6. Do you, the jury, unanimously find that defendants Peter Evans, individually, and DBA Midway Motorsports Park and Flipside Motorsports, LLC, established by the greater weight of the evidence that plaintiff Charles Smith and Company, LLC, is liable for gross negligence? No. We, the jury, unanimously find the defendants Peter Evans, individually, and DBA Midway Motorsports Park and Flipside Motorsports, LLC, are entitled to $16,358 for the plaintiff Charles Smith, LLC, for negligence and or gross negligence. 8. Do you, the jury, find that defendants Peter Evans, individually, and DBA Midway Motorsports Park and Flipside Motorsports, LLC, owns negligence contributed to any damages sustained by those parties? Yes. 9. We, the jury, unanimously finds that defendants Peter Evans, individually, and DBA Midway Motorsports Park and Flipside Motorsports, LLC, negligence contributed to the amount of 50%. 10. If you, the jury, answered yes to question 6 above, do you unanimously find that defendants Peter Evans, individually, and DBA Midway Motorsports Park and Flipside Motorsports, LLC, established by clear and convincing evidence that they are entitled to recovering punitive damages from Charles Smith and Company, LLC? No. And it is signed by the foreman. Ladies and gentlemen of the jury, is this your verdict and still is your verdict? Please raise your right hand. All hands is raised.
All raised. All hands are raised. All right, is there polling requested?
None from the plaintiff, Your Honor.
None from the defense.
All right. Very good, ladies and gentlemen. You worked long and hard, and you've returned a unanimous verdict. Thank you very much. Are there any post-trial motions?
Yeah, we request 10 days.
All right.
Your Honor, we would ask for the same 10 days. So wait, the hours later.
All right. So the party will be granted 10 days to file any post-trial motion.
My name is Aubrey. My name is Reagan. My name is Riley. And my name is Robert. For the best news, turn down the bass, push that button, and follow us.